The judge in the case of the death of George Floyd has dismissed the third-degree murder charge against Derek Chauvin, leaving only a second-degree murder charge and a second-degree manslaughter charge remaining for the state to prove against that officer. Why did he do it? What does it mean for the case? Let's get into it. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we are talking again about the death of George Floyd and the most recent update, which is dismissal of the third-degree murder charge against Derek Chauvin, which, in my opinion, leads me to the idea that Derek Chauvin will likely not be convicted on any murder charges and may instead be convicted only on a manslaughter charge, if anything. I do not believe that the state will be able to overcome his justified use of force in the second-degree murder charge. But we'll talk about that in a second. Let's quickly do the legal take. We're going to do this segment called Legal Take, Hot Take, I guess, where I'll give you my legal opinion on what happened. I'll explain what happened with the legal terminology and the legal reasoning behind it. And then I'll give you my personal take on how this is all going. That'll be the hot take, all right? So stick with me for a second. Let's do the legal take here. This is from the opinion. Now, the opinion on all the dismissals is 107 pages. We're not going to go through all of that because it would take a long time. We'd be here for a while. But instead, we're going to focus just on this section, which is that probable cause does not exist for the third-degree murder charge against Chauvin. And in particular, this highlighted section that I have, which are the three elements that the state would be required to prove to sustain a third-degree murder charge against him. Now, let me give you some caveats and disclaimers real quick that are really important for my sanity in the comment section. Yes, I have seen the videos. I am aware of the argument that Derek Chauvin, or that George Floyd ate a pile of drugs during the arrest and that he overdosed on fentanyl and meth and everything else that you can possibly imagine. I am aware of those arguments. They are fine. They're great. They're actually very compelling arguments. All right? At this stage of the case, they do not matter. So please don't flood the comments telling me about all of the things that George Floyd died from that weren't Derek Chauvin, because they are irrelevant to this particular aspect of the legal analysis. All right? I get it. And very likely, the defendants will raise this issue at trial. But that is a matter for trial. This is a pre-trial dismissal for lack of probable cause. It's brought by the officers, which means that the state is the non-moving party here. So that means that as for a pre-trial dismissal in both civil and criminal cases, the non-moving party gets deference on questions of fact or fact issues. Okay, so in this case, we've got state says George Floyd died by Derek Chauvin's knee. All right. And their facts presented are evidence from the Hennepin County Medical Examiner, as well as the U.S. Army Medical Examiner, who was brought in and concurred with the Hennepin County Medical Examiner. We'll talk about that in a little bit. But they both suggest that the knee on the back of the neck was at least a substantial factor in the death of George Floyd, and that they ruled it a homicide because of that. All right. So on the defendant's side, though, you would have the argument of, well, he ate a bunch of drugs. He had elevated levels in his toxicity report, which may be fatal at that point. Okay. Now we have these two competing sets of evidence, right? At this point, the state's evidence automatically wins because they're the non-moving party and they get the deference on the fact issue. So if they raise any facts sufficient to, or any evidence sufficient to support their facts, they get deference on it. So I just want to get that out of the way before you spend a lot of time typing about how he ate drugs and that's what killed him. That very well may be what killed him. It's not my opinion on what killed him. I don't really care. I'm just pointing out what the reasoning is in this case at this point. All right? Please feel free to leave any other comments. I mean, you could tell me about how many drugs he ate too. I guess that's fine. I just don't want to waste your time. How's that? Okay. And I counter-argued all of those comments that are coming anyway right now. So see the video. Okay, here we go. So the 3 things they have to prove. George Floyd died. And written into this sort of, excuse me, by inference, is that he died in Hennepin County or as a result of acts in Hennepin County. And he died as a result of acts that occurred on the alleged date back in February when this all occurred. All right? So that's wrapped into that. That Derek Chauvin caused Floyd's death, that he is the cause of death. All right. I already talked about how that occurred. Hennepin County Medical Examiner and U.S. Army Examiner both conclude that the knee on the back of the neck is a substantial and significant factor in the death of George Floyd, have ruled it a homicide because of that. The U.S. Army Examiner actually went further than the Hennepin County Medical Examiner, suggesting that the knee on the back of the neck caused compressive and mechanical asphyxiation, which is the Hennepin County Medical Examiner didn't quite use the words asphyxiation. He just said that it was a complicating factor in his death. All right. And then the third element they have to prove at trial will be that Chauvin's intentional conduct that caused Floyd's death was eminently dangerous to other persons and was performed without regard for human life. Such an act may not have been specifically intended to cause death and may not have been specifically directed at the particular person whose death occurred, but it must have been committed in a reckless or wanton manner with the knowledge that someone may be killed and with a heedless disregard of that happening. Okay, so it has to be an unintentional death, it has to be imminently dangerous to other persons, and it has to be performed without regard to human life. And it may not be specifically directed at a specific person. Okay, so where did the court decide that this didn't happen? And it's all at that last place. The court here reasons that Derek Chauvin directed all of his activity at George Floyd and at no other person. All right? And so the way he reasoned this out, the judge, is that since he directed all of the activity at George Floyd, that it can't be third-degree murder because the third-degree murder statute requires you to direct it at more than a specific person. I disagree with this reading of the statute. There are some cases in Minnesota that also disagree with this reading of the statute. They are very rare, and there's a good reason. I think that this case is an outlier that actually is what third-degree murder contemplates, personally. The judge here disagrees with me, so it's gone. My opinion doesn't really matter. And we'll get away from my opinion in just a second. But I just want to point out that there have been some cases where where acts directed specifically at specific people were considered intentional murder, or were considered third-degree murder, or that at least the instruction for third-degree murder was appropriate. The big one that is in recent memory is Mohammed Noor. He is the police officer who a couple years ago shot Justine Demond in Minneapolis. He was convicted on third-degree murder after drawing his gun, pointing it at a person in the window of a car, and shooting her. To me, it's hard to argue that he directed his acts at anyone other than that person, but, you know, I'm not a judge, okay? And clearly, the jury found that that was third-degree murder. Now, that case is on appeal, and it is entirely possible for his conviction to be overturned, at least on the third-degree murder portion of it, because of that distinction. We'll have to wait and see. The other case happened back in 2000, I believe. And we're not going to talk too much about it, but the long and short of it is, it was two people, only two people around, and one person caused the hanging death of another person. This is actually back, it was decided in 2000 that the acts happened back in 1997. And what basically had occurred in the past is these two would play a hanging game where one would, hang themselves with a bed sheet, and then the other one would release them after they had, reached unconsciousness or whatever. But in that case, at this particular instance, the other person didn't release them. So it was ruled a third-degree murder. It was imminently dangerous to another person, was performed without regard to human life, with the knowledge that someone may be killed. However, I believe that person was actually convicted for intentional murder, first or second degree, but the third-degree murder charge was deemed appropriate in the case by the appeals court. And it's hard to argue that that's not just directing the acts at one specific person. But I think there are instances out there, including this case, where you could say that George Floyd or that Derek Chauvin didn't intend to kill George Floyd, and in fact, didn't direct any specific act with animus at George Floyd. I think his actions look very indifferent or reckless, which are elements of the third-degree murder statute. But I think that his acts don't look intended to kill him or even cause him harm. I think he just completely disregarded the safety of George Floyd, and that's what it looks like to me. So I think if they could go ahead and prove that at trial, that his act, kneeling on someone, either on their upper back or on the back of their neck, is imminently dangerous to other people, can cause them harm or death, and I think that he performed it with indifference to his safety. So I think that hits all the elements to me. But in this case, the judge has said that the appeals court requires, or that the way the courts have interpreted this statute require that there be danger to more than one person. Again, I don't read it that way. That's the way the court reads it. So quick recap on that, because I rambled a little bit, but basically the court determined in this case that the state would have to prove that Derek Chauvin's acts were dangerous to more people than just George Floyd, since he was just putting his knee on one person's neck and not running around knee dropping everybody in the vicinity. They have determined that is not third degree murder. Okay, so it is gone. There really isn't a bringing it back. I guess the state could try and appeal. They're not going to. They could try and appeal that particular issue, but no, it's not going to go. It's not going to happen. That one's gone. All right. So now what are we left with? Where do we go? This is kind of getting, I guess I'm mixing the legal take, hot take stuff, but we're left with now second degree murder and second degree manslaughter. And basically the second degree manslaughter is an unintentional killing. I think it's likely, if they convict Derek Chauvin at all, that it'll be that second degree manslaughter conviction. Because again, I don't think they have the evidence to prove intent to harm George Floyd. Now, second degree murder charge is the other charge that's up there. And what they would have to prove for the second degree murder charge is that George Floyd died due to an underlying felony act from Derek Chauvin. In this case, it would be third degree assault, which means that Derek Chauvin intended to cause and did cause substantial bodily injury to George Floyd due to his actions. Obviously, he did actions to George Floyd, and there is evidence to suggest that they contributed in a significant way to the death of George Floyd. All right? Like that, again, reading all the evidence in the light most favored of the state, they have that. The problem at trial will be convincing a jury that Derek Chauvin was acting outside of his justifiable use of force in administering the restraint of George Floyd. That's the problem that they've got. The third degree assault is an assault assuming there's no justifiable use of force. George Floyd was resisting the arrest. He was uncooperative. Three of the four officers felt the need to restrain him. At some point, the body cam video shows that he was not cooperating, not staying in the car. So the questions that the state have to prove go towards whether or not that knee is justified, and then whether or not there is a point where the justification fails, or I guess expires. Does that make sense? Now, there's evidence that they can show that, he sat on there for 4.5 minutes after he stopped moving, 4 minutes after his fellow officer said he couldn't find a pulse, all of that stuff. They can try and do that, but they have to show that George Floyd, or that the Derek Chauvin intentionally caused the harm to George Floyd and was not justified in doing so. That's going to be a really hard thing for them to do. I think the easier conviction is a second-degree manslaughter conviction. Now, it's a jury. It's a jury of people from Minneapolis. They could be very angry that their city burned down. They could be very mad about this. Lots of factors can play into the jury's decision, and they very well could sustain a second-degree murder charge based on that third-degree assault and causing the death. Oh, of course, there is the other possibility in that they successfully argue that George Floyd ate a bunch of drugs, died of an overdose, and would have otherwise passed away, even without the officer's actions. I think that's a tough sell, but it's definitely a sell they will attempt to make, and they may be successful on it. But second-degree murder, to me, I don't think they get it. Second-degree manslaughter seems most likely. A full acquittal is actually possible for Derek Chauvin. And at some point, I will go ahead and do a video on the defense of Derek Chauvin, even though I think he should probably be guilty of something. I don't like seeing police officers involved in the death of people. And I think that his indifference on top of Floyd was very, very uncomfortable. And I just don't think the situation was handled properly. I don't know if it's a manslaughter charge. I don't know if it's a murder charge that he needs to be held accountable for, but there needs to be accountability in some of these situations. That's me. That's my opinion. You guys certainly don't have to have the same opinion. I know George Floyd was no saint. I'm not out here speaking for his lovely charity work or anything of robbing people at gunpoint. That's not my intention. But just pointing out my particular opinions on this case. So anyway, I hope this helps clear things up a little bit. As a final recap, third-degree murder charges dropped because this court reasoned, based on appellate court and Supreme Court precedent, that there must have been more people in danger than just one person for them to uphold this charge. Actually, all of the other third-degree murder stuff looks fine in this case. It's just that part that the court took issue with, and they dismissed the few cases out there that kind of disagree with that proposition. But, that's how it goes. And so now we're left with second-degree murder and second-degree assault. I think they will fail on the second-degree murder charge. And their best case now is a second-degree manslaughter. I think the second-degree manslaughter charge may stick. That's an unintentional killing. And in this case, I really have a hard time finding anything to prove the intent to kill George Floyd. So, all right, guys, that's the video. Hope you enjoyed it. If you did, like, subscribe, all that stuff. We'll be following this case as it progresses. And thanks for watching. Hope you guys have a good day. Peace.